as a part of that advice, he's supposed to let you know the strength of the government's case and the possible sentence that you will be facing if you lose. My attorney, he didn't do any of those things, and I didn't understand it at the time. So he was telling me everything that I wanted to hear rather than telling me everything that I needed to hear. The things that I needed to hear was that the government had an extremely strong case against me. Welcome to In-N-Out Podcast, where we have dope conversations with extraordinary people who have been free from physical or mental prisons. And they take us along their journey of overcoming incredible hardship, pain, and struggle. I am Eric Jerome, and today I'm going to be talking about how I got out of federal prison. I was given a sentence of 151 months after falling a trial in Charleston, West Virginia, one of the most conservative circuits in the United States of America. I was given a sentence of 12 years and 7 months for trafficking marijuana, conspiracy under the RICO Act, leader organizer enhancement, money laundering enhancement, and obstruction of justice enhancement, because the judge said that I lied on the oath. And when he said that, he was disgusted with me, because that Judge Faber, said that he believed that the federal system relied on witnesses telling the truth. And he said he believed, and the jury believed, that I lied under oath. And he hated when witnesses lied under oath. And truth be told, I did lie under oath. But lying under oath and taking the stand and going to trial was actually some of the things that enabled me to be able to find my way and fight my way out and claw myself out of federal prison. It was under a legal procedure known as 2255, ineffective assistance of counsel. And this legal procedure dates all the way back to London. It's a quasi-civil and criminal procedure where you have to prove that your constitutional rights were violated. Well, most of us have heard before that we all have a Sixth Amendment right to an attorney. When you're arrested, we all know the phrase, you have a right to an attorney. You have the right to remain silent. Anything you say can and will be held against you. What a lot of people don't know is that not only do we have a right to an attorney, but we have the right to an effective assistance of counsel. So when I went to trial, I came up with this harebrained scheme where I was going to lie on the oath. Me and my co-defendant, we concocted this story. It was based on a dry conspiracy, which involved marijuana. Dry conspiracy means that there was no marijuana ever to be found. And it was just based on witness testimony and the theory of the case. Although there was actually marijuana, I did that. I was bringing marijuana and a lot of it to West Virginia and a lot of other places. The law enforcement authorities was never able to actually physically get their marijuana. So that's hence the meaning of dry conspiracy. And it was based on historical weight, meaning that people would come and they would testify that I bought them X, Y, and Z amount of marijuana over a period of time that would be added up, and then that would be used to sentence me later on if I was found guilty, which I was. I went to trial, I lost. For those of you that don't know, when you lose at a jury trial, that's the strongest type of conviction. Judges, the government, they hate to mess with a jury's findings. They want to let the conviction stand. So when you lose on a jury verdict, it's extremely, extremely hard to get that overturned. And typically, when you get sentenced in a federal trial after you've gone to trial and lost, they will normally give you the max as possible, because it's the federal government's way of punishing you for not pleading guilty and accepting your responsibility from the very beginning. They call it wasting the court's time, wasting money, time, and resources on the court. So at that point in time, I was hated by the judge, by the jury. I was from Atlanta, and I was bringing drugs. Marijuana, you consider that drugs. I don't. It didn't then, and I don't now. And apparently the government does neither, because we know that the sentences now are different than they were then. So I got this long sentence of 151 months of marijuana on a first-time conviction because of the enhancements that I told you about, and I was determined to find my way out. And it all started when I went into the law library in federal prison, and I started shepherdizing, and I started learning about a 2255, which is ineffective assistance of counsel, so that that Sixth Amendment violation, that constitutional violation. So you have to find a constitutional violation in order to prove that you're being held illegally or unconstitutionally. Most people just automatically oftentimes go to ineffective assistance counsel, which is extremely hard to prove. So I had to basically prove that my lawyer, my counsel, my attorney was ineffective. I had to prove that he fell below the professional standard of norms for the type of advice that an attorney had to give to their client. Mine started the pre-trial phase of the trial, which starts before you go to trial. This starts when you're actually making your determination on whether or not you're going to go to trial or whether or not you're going to plead guilty. An attorney is supposed to advise you. He's supposed to competently, intelligently advise you on whether or not you should take a plea or whether or not you should proceed to trial. As a part of that advice, he's supposed to let you know the strength of the government's case and the possible sentence that you will be facing if you lose. My attorney, he didn't do any of those things, and I didn't understand it at the time. So he was telling me everything that I wanted to hear rather than telling me everything that I needed to hear. The things that I needed to hear was that the government had an extremely strong case against me, regardless of whether or not they found any marijuana in the case. Half the dudes in federal prison are in federal prison because of conspiracy. One of the very reasons why they came up with a conspiracy charge is because a lot of times the government doesn't have actual drugs in the case. But what they have is they have witnesses to come to court and testify against you, and to testify as to what you were bringing in or how much drugs you had. Similar to when if somebody gets murdered and they don't actually physically catch you murdering the individual, but they have witnesses that will come in and that they will testify that they may have seen you in an area or they might have seen you do something to an individual, and then it's up to the jury whether or not they believe the testimony and whatever evidence is brought against you. And then if a jury finds you guilty, then at that point you're found guilty. So I commenced to finding some type of flaw in my case. When I got into prison, there was other inmates that had been down a lot longer than me, and one particular individual named Jack Cater explained to me that there's a flaw in every case. So I set out to find that flaw in my case. And once I was shepherdizing, which is finding one case that leads to another case that leads to another case, I came upon a case that was kind of similar to mine, and it was able to help me understand that an attorney is not allowed to put perjured testimony, basically lying under oath, on the stand. And one of the things that we did when we conjured up this story, myself, my co-defendant, and my lawyer, is to get together and come up with this story that we were going to present to the jury. The problem with that is my attorney knew that it wasn't true, and he agreed, unbeknownst to my co-defendant's attorney. He agreed for us to get together, get our story straight, and she and I would both take the stand, and that we would say that there was something other than marijuana that we were bringing up to West Virginia. And so when he did that, he was in essence, he was breaking the law, and he was also violating any codes of ethics related to being an attorney that have been established by the American Bar Institute. So I was able to start developing my briefs, and I was able to basically get back before my attorney so that I could develop and basically prove at an evidentiary hearing that my attorney put me in front of the stand under oath, knowing that he was going to lie. So this is the first part of it. We'll get a little more in depth in the second part of it. I'm Eric Joel. This is In and Out Conversations.